I'm a big foodie.
I don't like food. I love it.
It need not be Michelin star or, expensive, but anything that is nice. My comfort food can range from bak chor mee to porridge to Italian, so it really varies. Arbitration is really an alternative dispute resolution process. It is more akin to litigation, where you sue somebody, and at the end of the day, the judge will decide and issue a judgment, right, as to whether you succeed in your claim or otherwise. Arbitration is the same, save that it is less formal, because you are not in a court setting, and basically your judges, your arbitrators, are usually people with certain expertise, people from the industry. They can be lawyers, but not all of them need to be lawyers. So for example, in the construction industry, you may have some architects, quantity surveyors who may also be arbitrators. And needless to say, most if not all of these arbitrators would be accredited with the various arbitration bodies depending on where they come from. If a client comes to me with a commercial dispute, there are various things that needs to be taken into consideration. One needs to look at the nature of the dispute, what are the grounds, and what are the possible causes of action. Of course, the quantum of the claim also comes into play. And then one needs to consider issues like limitation. I think that is very important, and because the client needs to know what is his position, his legal rights and remedies, right? And from there, depending on the response as to whether we move on to the second stage, which of course depends on what the contract may provide, whether it is by way of litigation or arbitration. Of course, depending on the relationship between the parties, client's position and client's instructions, we can also consider alternative forms of dispute resolution, such as mediation or neutral evaluation. But these processes would require the consent of the other party. What is the difference between litigation and mediation? I would always tell my clients that mediation is not an adjudication in a sense whereby you get a final judgment or an award. Right? Mediation is really a very consensual process whereby parties are in control of the process and the outcome. It is really about parties coming together with a mediator involved in that process to try to resolve their differences and to find some amicable resolution. That results in the savings of time and cost, needless to say. Not for everyone to go through a trial process. You can imagine the time involved, the stress that's involved, going to court and then being cross-examined when you take the stand. Needless to say, the lawyer, the other side's lawyer's job is to break you down, right? In terms of your evidence, in terms of what you position, right? So that can be a very stressful and, dare I say, a painful experience sometimes for some people.